Just like yours, Kevin, it would be mine.
Welcome, folks. This is
Just like
Corrections
it'd be mine.
Institutions Committee. It is Thursday, February 12th. We're shifting gears. We're running a little late because our previous testimony went longer than we had planned. We are talking about H 549 as well as proposed language that the Department of Motor Vehicles has recommended to the Senate Transportation Committee on their omnibus DMV bill. We started working on our 549, which would allow detainees who have been detained for 6 months or more to be able to be eligible for a non-driver ID card. That was the basis of 549. What the language that DMV proposed is to clarify that the non-driver ID card that would be available to individuals who are sentenced, so it doesn't talk about detainees, so that's one difference, would be that DOC would submit documentation that would be required for a non-real ID or a real ID card, identification card. So I think our language of non-driver ID card and then the language that's being proposed by DMV really clarifies, doesn't change that non-driver's ID. The other change that's really that we haven't even looked at and how it plays out with our current law is when we updated folks receiving a non-driver's ID, we also allowed them if they, and I'm looking for the language because I know that Haley, I think we got it's other licenses. I'm trying to think where it is that, right, we have allowed folks that if they want to receive a driver's license while they're incarcerated, they have the option, if they're eligible, they have the option to do that, but they have to pay for it. So that's current law. And if you have the bill in front of you, 549, that's on page 7, and that's lines 13 through 16. Okay, so that's current law. We're not proposing to change that, but the language that is being proposed by DMV allows them to receive their operator's license. And I don't know what the exact language is, but if they have been, I think it's up to 3 years and they came in with a valid driver's license, they could get their driver's license, I think at no cost. So that's in conflict right now. And also they'd have an ability for a learner's permit, which we didn't even address. So that's what we need to work through. And then whatever language we come up with, we will have 2 passed. We do a strike all on H 549 to incorporate whatever language we work up with. But that language will also be submitted to Senate Transportation so they can put that language in the DMV bill as well. So there'll be two tracks. So is that confusing for folks? Okay, so maybe DMV, I don't know which one should come up first, DMV or corrections? Go ahead. Thank you, Nancy. You've been in here for a while.
No worries at all, Nancy. If you want. Thank you. I need coffee.
And then we will ask Monique, we will probably be asking you questions as we go along to see how it impacts. See, does that make sense?
For the record, Nancy Prescott, Director of Operations, DMV.
All yours.
Okay, so as you mentioned, DMV does have in our miscellaneous bill what new language, change of language for the DOC inmates upon release. Right now, current law states you will get a non-driver ID at no fee. Our language is proposing to change to get the individual the highest credential that they are eligible for which could now include a license or a permit in addition to, if they don't have eligibility for that, they would still get the non-driver. We're just trying to get the individual with the maximum credential they are able to. So instead of them going out with a non-driver, but actually were eligible for a license, they then come to the DMV to then get a license after they've been released. So we're just trying to get everybody out on the best foot initially and get them the credential that they are deemed and able to.
Let's do this step by step, and the language needs to be in front of folks, please. Because you have to see the language that is the DMV proposed language. It's been handed out to us, it's on our website. 740, well.
This- right.
Yeah, it's draft 2.1. It's draft request 26, 743. Because this is where the DMV language change is. So the first change is for the non-driver ID. Okay? The question was, right now, the law does not indicate the non-real ID or real ID identification card. So the question before us is, first part, do we accept the language that's in draft 2.1 or not? And one question a member had was, what does that non-driver ID card look like?
It looks exactly like everybody else's. It is not separated out, meaning that they are to look like a DOC inmate or anything like that. It is anybody and everybody's non-driver ID that one would get. They look exactly the same. And it has the same criteria as well to get.
I think the question was, does it look different than our driver's license?
It says non-driver ID, non-real ID, or real ID. But the header is non-driver ID.
Thank you.
So does the real ID get you on a plane? The real ID,
Non-driver,
The
real
non-driver,
ID
real
Yeah.
ID
on a plane.
does get you on.
And
Yes.
across the border.
No,
It doesn't.
no. An enhanced driver's license that has a chip in it for an additional fee, which is not part of our proposed
Gotcha.
language,
Okay, thank you.
gets you across the border.
Okay,
Thank you. Just wanted to be clear.
Say that again. What's that called
An
again?
enhanced driver's
Enhanced.
license, and I'll add it, one more layer to be confusing. It is also a real ID.
Right, that's where I was.
right.
So,
Enhance,
That's correct.
That's an extra step on.
mhm.
So,
It's got more than a star.
It says enhanced on it,
Literally says enhanced.
but it does have the star as well,
Right.
because the star represents real ID.
And the flag too, right?
The flag is
Sorry.
for the veteran designation and so forth.
No, this,
he's wired up because he's got problems with his back, so it's kind of jabbing.
Oh, no.
what you gonna take it? Yes.
And you have an enhanced, yes.
Yeah,
Yes.
that's the enhanced.
Yes,
Yeah,
it
yeah,
is.
Rub it in.
Mhm.
Well, you have a flag on yours?
Yes.
You gotta go get it.
You can't go across the border, so you can't.
That's why I have my, passport at the hard way.
Everybody's taking out their licenses. I love this. We're doing show and tell.
See, I don't, thought I did, because that's what I asked for. I got to
I
the
have
border
enhanced.
and I didn't have my passport in my car. But the Canadian guy saw my state police and he goes, "That's who you are."
Oh,
There's a lot of confusion.
Unfortunately,
Unfortunately, that isn't something that we can, a real ID is designated as the real ID. I mean, even the lettering of the real ID versus non-real ID incorporated in it is
I learned a lesson that day, never leave the DMV without looking at it.
fair enough.
So what we've got before us right now, so this would not change your practice that you have where DOC does submit the information for a non-driver's ID, whether it's a real ID or a non-real ID. DOC submits all that information that's needed. to DMV, and DMV processes it at DMV's cost
That's correct.
at about $3.30 per card. So there's no charge to the person who's incarcerated, but you have to substantiate the documents, which could be a birth certificate or social security number, proof of residency. Maybe that's going to be tough. But DOC provides all of that information on behalf of the inmate, the offender right now, to DMV.
That's correct.
That's for the non-driver ID. Okay? Now, the way the law is right now, it's only for folks who are sentenced, and they will have served 6 months or more. The DMV language does not change that qualification. Okay? The bill before us would allow detainees to have access to non-driver IDs if the detainee has served 6 months or more. And what does that do to your process or anything different?
Haley and Monique were able to get us the numbers. And the numbers from 2022 to current
For detainees,
for detainees, well, that's what your bill, H549. Detainees is where the word's added in. There was 188 that would have been eligible.
Between 2022 and now.
That's correct.
Not
calendar
per
year.
year. That's
No. That's correct.
For individuals who have been in.
I put it was something else.
Yeah, for the criteria that they are proposing.
How many a year?
40.
Times 3.
Okay.
So if there was 40, that's about 40 a year. This is calendar years or fiscal years?
Calendar.
Because that does make, it's really important to know to figure that out.
If it's calendar, how can 26 have anybody?
Well, up to date, we've got 26, we're halfway into it.
But we were told calendar, not fiscal.
Someone
Oh,
could be
yeah.
detained before 2026 and then they hit their 6-month mark in 2026.
Thanks.
So, yeah,
So I think one of the things DOC had shared with us was one of the challenges was you don't know when a detainee is going to be released. So they actually could be starting their sentence and then released.
so if there was an average of 40, 45 folks per year, what would that do to DMV and ability to do it? And you would still be picking up the cost.
That's correct. This is a very minimal impact in a positive direction. The only thing that the DMV would like to put forward is this would be easily adoptable to put into place to include detainees. We just need system change in order for the zero fees. And our process would change regarding detainees specifically versus inmates. So we would ask that it does not go forward upon passage versus giving us the opportunity to do the system updates. We just went live in November with a new modernization and we still are working through some high priority SQRs. So we would ask that you give us the fluidity to give us a deadline of January 1, 2027 in hopes we have it done prior, but just not to run up against a quick deadline to meet it.
But you're not anticipating that the cost of this would have drastic impacts on your budget.
No.
And we did talk that DOC, what we did talk about, which I hope folks remember here. We did talk about DOC would put together for the detainees. They would put together the information for folks. Once they've hit that 6-month mark. But I wasn't clear if it would be submitted to DMV at that time, or it would be, you would wait until the person was actually released And then the information would get submitted, and then the person will go down to the DMV office to pick it up. So I want some clarification on that. Any,
You could get a, so
you identify yourself.
I'm sorry, Monique Sullivan, Department of Corrections, Facility Operations Manager. Department of Corrections can get a social security card and a birth certificate, like a social security card for anybody and a birth certificate for anyone born in Vermont. And have those two documents ready. So if the person is detained and they're in for 6 months and the charges get dropped, for example, and they're free to walk out the door, we can hand them those two documents so that they can go to the DMV and have the paperwork they need in order to get an ID.
And can we still? I don't know what my question is. Is that always, is that the default, anybody, or can we, because you have IDs coming to the facilities for folks who are sentenced, right?
Correct.
Can we do that to any degree for folks who are detained if there's a predictability of their release?
There really is no predictability
Okay.
of release. Sometimes the charge will get dropped completely. Sometimes after serving 6 months, the judge will decide that it's credit for time served and he can go. Sometimes it takes
Okay.
years. The longest I've seen someone detained is 5 years.
Yeah.
So in 5 years, whatever ID that you would get
Yeah, yeah,
is
yeah.
going to be invalid.
So,
No, you-
one clarifying, so the default then is this, here is what you need, go here to get it. For detainees,
Yes.
okay, and that's probably the best.
So where are we? If we expand the DMV language to our language in the bill for detainees that have served 6 months more qualify for a non-driver ID that would be a non-real ID or a real ID. So DMV would not see a drastic impact in terms of your budget. The issue is to allow your system to be changed. You would want the effective date for this piece to be January 1st, 27.
That's correct.
And then we would probably, and I'm gonna ask some folks to help me out here, because we're gonna have to get back to Hillary, because we're gonna have to have language changes here. Would it be helpful to have language put in the DMV, the DOC would get the documentation for the detainees that are needed? And then when the person is released, that goes to the person to go to DMV.
Yes.
So you would need language in the bill to explain that. Okay. So we'll have to have that drafted.
Just to clarify, if I could, you mentioned DOC would then give the detainee the little Ziploc bag
Well, that's what I'm wondering.
of goods, not coming to DMV in the manner that we currently do, just to clarify.
Just for the driver's license or for the
No.
entirety? For everything?
This is non-driver ID.
Detainees.
We're not on driver's
Okay.
license.
Do the Ziploc bag.
Driver ID.
The reason I asked this, because why would we not continue it in the same process?
But we'll get
Okay.
there. I want to get the non-driver ID taken care of first. So would the information that you've gathered from the detainee be sent directly to DMV while the person's detained, or would you wait until the person is released?
We would wait until the person is released, hand them the documents.
And then it would be up to that detainee to go to DMV. Why would you not, for someone who's been there for more than 6 months, why would you not send that information to DMV while they're still in the facility?
We could send it so that they have it.
And what would happen on your end if they did it?
I don't know that we would propose to actually receive it prior to actually having a transaction and a record to attach it to. I wouldn't want to have a file cabinet filled with birth certificates and social securities if I don't have a record on the system to
Right.
attach it.
We already have a filing cabinet for first.
That's fine. That's why I asked the question.
Yeah,
So where's the committee on this piece? Non-driver ID. It would be a non-real ID or a real ID, which is a tongue twister. Which is no different than really what is currently occurring. DMV is only did for sentenced individuals. Okay, our bill would also include detainees who have served at least, not, have served 6 months or more. So where are we including detainees?
Absolutely.
Yeah, I'm fine with it.
And then we need to put in some language that DOC will collect the verifying identification information when the person is released. That documentation is given to the person to go to the local DMV to get their non-driver ID. And hopefully, if they get released right from court, how would you get that information to DMV? If the person doesn't come back to the facility?
Many of our court proceedings are remote, so they don't actually leave the building to go to court. It happens in the facility. Or if they leave, it happens now anyway, that if a person goes to court in person, that they can get released. Then they have to come back to the facility to get their property and get whatever funds they might have left and that kind of thing. So we would just be able to give it to them then.
So we're clear on this one?
Yeah.
Okay.
yes.
We're clear? Okay.
Yeah.
Now, for driver's license, for current law, and we did this in the committee, were you around? You were around. Troy, you were here, right?
The first year, we were, yeah.
Yeah, we did put in where, and this is just a sentence person. And our bill before us does not, well, it would include,
It's on page 5 of Damien's draft 2.1.
no, but I'm looking at current law.
Oh,
This is where I wish we had our legal counsel here, but I think she was tied up. If you go to page 7 of our bill,
Mhm.
in current law, lines 13 through 16. As part of a reentry planning, DOC shall inquire with the individual to be released about the individual's desire to obtain a non-driver ID card or any driving credential, which would be their driver's license.
Right. Perfect, yeah.
Inform the individual about differences, including the cost to the individual.
Mhm.
So that's where we're saying a person. Now, I'm assuming this would be a sentence person.
current law is sentence.
Doesn't say that.
I think it does earlier in the statute. Because we weren't.
It says an
contemplating detainees
individual,
yet.
it says an individual sentenced to serve. It said-
We didn't mess with detainees the first
No,
time.
we
were doing
didn't.
this.
We were just focused on sentence first. So if you look on on line 4, what we're changing is individual to inmate.
Mhm.
An inmate is defined inmate is defined as everyone in the facility,
Mhm.
regardless if they've been convicted or they're a detainee.
And
And,
actually changed the language to incarcerated individual. That
pardon?
Department of Corrections changed it to incarcerated individual. So that it wouldn't, there's no differentiation between sentenced or detained.
And where did you change that? Internally, you've done that? But we have a definition in statute on inmate offender. We have a definition. Offender, by definition in statute, is someone who's been convicted. An inmate is someone who has not been convicted, which is basically a detainee. Or is it the other way around? Gotta be the other way around.
No, offenders are the individuals who have been convicted and sentenced, and inmate is everyone's.
Inmate is everyone, yeah. So what we're saying on line 4 is everyone, anyone who is sentenced to serve a period of 6 months or more, or is detained. Okay? Lines 13 through 16, we're saying an individual. Do we need to clarify what we mean there? And that's a question for our legal counsel, because we used an individual up on line 4. Because we're very clear, it's only sentenced folks who get a non-driver's ID. So now we're expanding that to also include detainees. So the language 13 through 16. So right now, we are allowing someone who is sentenced that is eligible to receive a driver's license. They can do so, but they have to pay for it. That's current law. And we're not changing that for folks who are detainees under age 549. So the draft language that's coming from the DMV, and you got to pull out the language.
Page 4.
Yeah, but it's under different, trying to see if it's a different 613, so it's in a different section. You know, we don't talk about this at all in our bill. So in the driver's license section of DMV's law, you are indicating a person who is sentenced. That's your,
You're on page 4.
on page 4, yeah, a person who is sentenced and who holds an unexpired license that's issued in Vermont. And it would not, and the expiration is not more than 3 years prior to their incarceration or their sentence.
In order to have a valid driver's license and not need to retest, you must have a valid driver's license that has not expired for more than 3 years.
So the language is drafted here, does that include both a sentenced person and a detainee?
No. For us, at DMV's miscellaneous, is the language is specific to inmates of 6 months or more. It has nothing to do with detainees at this time.
So if they've been sentenced and their driver's license is still valid, or it's been, has not expired more than 3 years, so it's expired 2 years previous, they would be eligible for a replacement driver's license.
Exactly. Where our current language says we would get them a non-driver ID. So now we are getting the highest credential that they can possess.
How many folks in DOC come in with a valid driver's license and then they're there for longer than 3 years and then the driver's license expires?
I have no idea.
Some,
Many.
probably, yeah.
Come in with a valid driver's license. So with the,
For more than 3 years. I don't know.
And one could renew online to even while they're incarcerated. No, a family member,
That's outside of, if
right?
the family, if mom wants to do that, then great for mom, but.
Yeah, so
person
you,
incarcerated.
fair, because they don't have access to, right? But yes, we have seen that where family members have, or we're making the assumption that the family member has renewed one's license. People don't like the idea of retesting.
So there's two qualifiers. The person comes in, is sentenced, and holds an unexpired driver's license that's issued in Vermont, which we have to be very clear in language that it's in Vermont. That would be one scenario.
Mhm.
The other scenario is the person needs to be sentenced and has held a Vermont driver's license that expired not more than 3 years prior. So is it 3 years prior from the time that they entered as a detainee or from the time they were sentenced?
From the time the license expired.
That's correct.
That's it.
Has-
Has nothing to do with,
Their status. So if it expired, they came in, they were a detainee, and it expired a year into the time frame they were still a detainee. And then they were sentenced to 5 years. So 2 years into that sentence, they would then be able to qualify for a driver's license.
If they were being released,
They'd have to test again.
if they were being released prior to that 5 years. Or unless somebody else renewed it for them, but in theory, they would have been out of that 3-year range in that scenario that you just mentioned.
If they're within the 3-year range.
Expiration. Mhm.
So they would have had to, my question was, they came in with a valid driver's license.
Mhm.
And it expired. They were a detainee for a year and it expired during that time frame. And then they were sentenced to 5 years. So at the second year of their incarceration, is within that 3-year window,
Mhm.
they would be able to qualify for renewal of their driver's license.
They would not, according to what we're hearing, that they would renew it
It could be renewed.
It could be renewed.
online.
Right. While they're still incarcerated.
So long as a photo doesn't need to be updated as well, right? Because we have 9 years.
That's what I'm trying to figure out. Is it while they're incarcerated? Some of them are gonna have an incarcerated time longer than 3 years. And then who pays for it?
They would continue, so if they didn't qualify for a license under our current language right now, if they didn't qualify to receive the highest eligibility of a license, they would be getting a non-driver ID under our current law.
I'm looking at the language of DMV's proposal.
Right.
Okay, I'm trying to play it out in DFC's world. It says a person is sentenced and they hold an unexpired license.
Mhm.
So if they're sentenced and they hold an unexpired license, how do they renew? Can they renew it while they're incarcerated?
The person incarcerated does not have access to a computer to renew. Or to a credit card to renew.
somebody could renew it on their behalf.
Right.
According to the, whatever standards are in place for the DMV, the fee, making sure the picture is current.
Mhm.
But no, the incarcerated individual could not.
And who pays?
Who's ever doing it on their behalf.
Yes, not us.
So while they're incarcerated, so the other option is person held an operator's license, a driver's license that has expired not more than 3 years prior. What would be the starting point of that, the time that they came in as a detainee?
It's all about the
Doesn't matter.
credential,
All about the.
all about the credential from the issue date to the time that remains on it or the time that has passed from the expiration. As nothing to do with the time of a detainee or inmate. It's what they're eligible for from the last expiration.
So if that eligibility expiration date is like a year before or something, are they gonna have to start from scratch for verification of identification?
So we have a Vermont license in possession. They have 1 year past expiration. It's a Vermont license that they possess. They're now then getting released or detainee, right? We're getting released after that 1 year.
This says, an individual who's sentenced, so you're not talking about detained.
Okay, so I just wanted to clarify which one. So for us, they pass that 1 year. They have up to 3 years from expiration that they won't have to be retested, and we would give them that driver's license.
But that would be upon reentry.
That's correct. Not while they're incarcerated. This is all about when they're released.
Is that the understanding of DOC? Because the language does not say that. It doesn't talk about reentry. It only says as part of the reentry, DOC would inquire if each individual regarding whether the individual would like to obtain a driver's license and shall provide the individual with the information. We need legal counsel. We need a lawyer in the room.
Yes, we do.
We need a lawyer in the room.
There.
Because I'm not opposed to looking at this or doing it. I think we've got to make sure the language works in DOC's world. The language works in DMV world. We know what we're doing. Am I the only one that's feeling a little mushy here?
No, we need it in front of us.
Yeah, you're absolutely, to me.
I mean, I know the language came from DMV, so you're looking at it through DMV's lens, but we're looking at it through your lens, but also DOC's lens.
I had some thoughts in my head, but I'm like, Joe, you know what? You're not a lawyer. So kept it right in there. As far as trying to like resolve some of it, like, inmate versus individual. Something an attorney should chime in on.
We have a definition of inmate, we have a definition.
I hear you.
Are you folks, what do we have on the floor tomorrow? We have a lot.
You have me set up for tomorrow regarding H 549 specifically.
12 at 12 o'clock. Do we have a lawyer available?
You will be. Yes.
And DOC, are you available tomorrow
At some times, yes, I know that it's currently on the schedule for
at
June.
12?
Is that still, yeah, well, we can be here, I think we'll be remote, but.
So we really need to get, because I've been asked 3 times by Senate transfer, where's the language? I said, well, we're scheduling people to come in, but we need a lawyer here.
Pretty light on the floor tomorrow, it looks like.
Yeah, well, we've got VHCB after the floor. And if we're off the floor, I mean, we're gonna take lunch at 11:30 tomorrow.
Looks like we got one, there's only one bill on the notice calendar today. 898.
What does that pertain to?
Copper base to fiber based telecommunications
Copper.
network transitions.
I wonder if there's a fee or appropriations to that. Yeah,
Well, it's only Sibilia for energy and digital, so it's warned.
well, it's on notice. Yeah.
You're correct. You're talking about Friday, right? So,
What was the vote on that?
it's like-
It was unanimous. if I remember.
So we have VHCB. Depending when we get off the floor, then we have lunch. We've scheduled you for 12, let's keep 12 o'clock. Well, and Hillary's available,
Yes.
and she's working with Damien. Because Damien staffs DMV.
That's correct. And I know the last time we were here, you were looking to mirror the two
Right, that's what-
statutes together. ideally.
So we've done the agreement on the non-driver ID. We're fine with that. I want to get pulse of where the committee is in terms of pursuing the DMV language for folks to get their driver's license if they were eligible and they had one and it expired while they were incarcerated, that they could reapply. Are we fine with that for folks?
Definitely.
Yeah, it's a absence of a hurdle, but
And it would only be for sentence folks. Okay. So we'll follow up on this tomorrow with you folks. Thank you for sitting in today and dealing with us.
Thank you.
Thanks very much.
It's been a morning of GOC. Oh, my driver's licenses have to be so complicated. Okay. Judge Zone is not by any chance on Zoom yet, is he?
I saw him in the hallway earlier.
Here?
He's spamming us up.
Yeah, I saw him hanging out in front of by judiciary, talking about Arsenal and,
He's still out there.
remember?
Haley, can you see if Judge Zone is out there? Yes, we're ready for him.
Okay, everybody.
yeah,
Thank
you-
you.
He's not out here, but if I see him in the building, I'll let him know.
Great, yeah.
Yeah, unless there's some shenanigans, it doesn't look like we have much
We're-
tomorrow.
We're still live, folks. I hate to go off and then come back
Well,
on.
you're not a lawyer, Joe.
But he did say that.
I'm
sure.
Be
The caveman.
Be aware, folks, we're still on YouTube. We've got 5 minutes. I kind of need to go off of YouTube and then get back on. So Judge Zoney is going to talk to us about pretrial supervision and how it works on the court level. How are you doing there, Troy? Really,
We're back.
yeah,
How long has that been going on for?
since yesterday.
yesterday's shovel fest.
Is it any better today?
It's really bad after I've been sitting for a while.
Oh,
Do
the
you-
sitting is not good.
You use chiropractor?
No.
Do you believe in it?
That's a long.
Okay, because I got a great guy at St. Barry that can usually fit people in.
You use what?
Chiropractor.
Judge is right up.
Oh, good. Yeah. I don't. Can we get started? That what?
Another. I mean, I'm not attorney, but it seems like you could just define individual inmate, somewhere toward the top of the bill. And then just be done with it.
Well, tell your real lawyer to conform it.
Yes.
Yep.
I would think.
Welcome. Almost afternoon.
How's your knee?
It's great, thank you. It's doing well.
It's your beard though.
All right, we're getting there.
I'll race you.
We're
I'm
getting,
ready to get started with you if you want to
Okay.
go.
works, thank you.
Yeah, we're a little early.
I'll race you.
And yeah, the two canes.
It's not listening.
Yeah, I'm trying, I believe I shed the cane in the next few days, but right now it's something good to have because it A, reminds me, slow down. And B, there's a factor where it seems that when someone watches somebody coming at them with a cane, they'll walk away, which reduces people running into me.
Yeah.
We know Mary will attack. Her cane. Be careful. Here comes the cane.
Yeah, just in time for the gift.
Welcome, Judge. We did miss you yesterday, and I hope it seems like everything went well for you.
Yes, it did, thank you.
So we want to talk to you about pretrial supervision. And we had the defense and the prosecution in yesterday. And we're just honestly trying to figure out where to go with the program. We really are. It has not been utilized very much. And it was really interesting to hear from the state's attorney mentioned what folks should be participating in the program. Is it your lower risk folks with a goal to keep them out of the criminal justice system? Or is it really your higher risk folks to divert them from being a detainee? And then the other piece was, do we just look at folks who don't show up? Or they continue to violate their conditions versus the 5 dockets. So that's kind of what came out yesterday, because those are kind of the stumbling blocks, number one, of why some folks aren't going into pretrial supervision. The other piece of pretrial supervision, it is voluntary on the part of the defendant. And there's some hesitancy there from the defendant to participate because it almost assigns a sense of guilt and admitting to guilt. So we're just trying to figure out, well, what do we do with pretrial supervision? Is the program worth continuing or not? How does this play in if we expand the accountability courts? Because there's 500,000 in the budget to do that somewhere in the general fund budget. There's 200,000 in the budget to hire 7 permanent PMP officers, monitor this program. So we're just trying to figure out, number one, why are there not many people in it now? We got some reasoning for that yesterday. Is the structure of it structured correctly? Do we go forward with it? And then, of course, there's proposed changes in language that both the Council of State Governments and the administration has proposed, that we as a committee have not looked at those 2 proposed languages together. Just trying to get our head around the pretrial supervision program.
So Tom Zonay, Chief Superior Judge, I was just talking about this topic next door down
I'm
the.
sure you would, because
So-
they want to take this and work on it.
So I will tell you, when I think I started with there, I was joking with Representative Goslin because he always says, well, you come in, you say it's policy. So I said this morning, this morning I said, Representative Goslin, can you say what I'm about to tell you? And he laughed. He goes, it's a matter of policy. And so where do we go? What happens in the state and what you do with it? Obviously, it's a policy. But what we know is that, as you pointed out, it hasn't been utilized. When the money was set aside a few years ago to do this up in Orleans, the plan comes out, let's do it in Orleans. It was a lot of money that was set aside to stand up this program. The thought, I testified downstairs in Senate Judiciary at the time. My position was, in some ways, it's trying to go in the direction of the federal judicial system, but it's not going to get there. It's almost federal supervision light. We have different laws, we have different structures, and we don't have the resources to do what the feds do. For those who don't know, if you're arrested in the federal court, before you even meet with, let's say there's a drug bust, the way it would work, and I leave open that maybe they've changed it in the time I've been on the bench, but I did a lot of federal defense. That was the majority of my practice. They do a drug bust. They arrest the people. The people go to the jail at the courthouse. They call out to get lawyers for the people. Before the lawyer has even met with their client, probation and parole, who is actually an arm of the judicial branch, they work for the judge, they would have already met with the people, found out their history, background, and they come up with a pretrial services report. So for every case, the judge is given a piece of paper that talks about family, history, everything that we want to have. In Vermont, a person's arrested, they come to court, the police may give us some information, the state's attorney will give it, the defense may give it, and that's what we have. We don't have reports. And so this was never going to be a federal pretrial supervision. And it seemed like the bill was intended to address really 2 separate and distinct issues. One, people need help identifying and getting to resources. How to access resources, what resources are appropriate, what might you need for evaluations, things like that. And 2, some people keep violating conditions, and you want to keep an eye on those individuals to see whether or not they're violating and take steps to address that. We then had, I think, 2 people who've gone through it. I'll stay away from the lack of utilization that I understand it was discussed yesterday, but For whatever reason, it wasn't utilized. And so what then happens is the pilot docket starts up. And we have this program brought over to the pilot docket. And I think a lot of us thought, okay, here we go. This is going to be where pretrial supervision really starts getting used. And it wasn't. And if you take a step back and say, well, why wasn't it used? If this would seem like what it's for. Well, what did we realize in the pilot docket? We had wraparound services. We had people coming in to talk about resources. We didn't need a court order necessarily to come in and do an evaluation and come up with under 7555. We needed people there. Give people the time, the resources, courtroom to talk. It was the way, as someone commented to me, it was the way the system used to be 20 plus years ago when we had more time and people would come in and talk. What we learned was that it worked to get people to the resources if they were there and they were helpful. And what else did we learn? We heard yesterday testimony, and we've had meetings about the pilot docket for expansion with the stakeholders, where DOC was a significant benefit, an asset to what was happening. They were helping throughout. It used to be plea agreements are entered. If you don't have a liaison there from DOC, you send it over, and then people don't know what's going to happen. DOC may take a different look. Who's going to be treatment? Can this plan work? My understanding is what was happening in the pilot docket is DOC was coming in sooner. DOC was there at the table saying, okay, we can make this work, and helping to facilitate things as that liaison. It didn't have to be under the pretrial supervision program. They were doing that air traffic control, and it worked. So the question for your committee is, do we need this type of, and the legislature for that matter, do we need a bill like this and a structure that sets up to have DOC do what we just saw they can do anyway? And the next question is, the other aspect of it is, the second part is, what else were we trying to accomplish with this bill? Well, I think Senator Sears and your committees were all clear. We want to keep an eye on people. Well, is this the only way that you can get someone to monitor? Years ago in Rutland, I knew there was times where law enforcement would go at their office, see who had conditions of release, or they'd call the state's attorney and say, who do you want us to check on? And they'd go out and check on people for curfews and things like that. And I would tell people, just so you know, police might show up at your door one night and ask, and you better answer the door when they show up, or it's going to be a violation possibly. And so things like that worked. And I mention that because the challenge that you have is, do we try to fix something that no one's used and it hasn't been utilized and it costs a nice amount of money? Or do we say, well, we can accomplish this in a different way, and maybe if they're going to hire 7 more people from DOC, maybe some people become what do they want to call them? Monitors, and they can go out and monitor people on conditions of release, set up a system, something like that. In some courts, and I keep using Rutland because that was where I spent most of my time sitting, we would have DOC come over from next door and sit in the courtroom during the day as a resource. I can't tell you how many times they led their presence and their actions led to resolution, led to a more informed resolution. And if you will, found people. Someone doesn't show up, the probation officer would say, hey, hold on, judge, let me go make a call. And they would call and say, I just talked to their PO. Their PO just called them, they forgot. They can come right away. Things like that. That's the way it was done. And so you might want to look at things, and again, it's your policy decision, from the perspective of, is there a different way? We tried this for 2 years. It didn't work. It cost X amount of money. Is there a way that we can take the benefits of what DOC can do and implement them in a way that doesn't require something that nobody's using anyway, and we're told costs a lot of money? Can the money go to something else? We will be expanding the pilot dockets. That is the plan. It's not going to look the same everywhere. Some counties don't need it. But we're going to be taking steps to build on the momentum and the benefits we have.
So my understanding is there's $500,000 in the governor's budget to expand that accountability.
So is your understanding, and
Is that true or not? I mean,
Well-
I haven't seen.
so the BAA has 500,000 in it.
What does-
The Budget Adjustment Act
Okay,
has 500,000. Plus the 2027 budget does have, I believe, on page 9, a reference to $500,000 for fiscal year 27.
so is that on top of the? So
Uh,
500,000 and for the remainder of this fiscal year, and then another 500,000 for the full FY 27.
That is what my understanding was. I do understand that there's some question as to whether the 500,000 for fiscal year 27 is actually there. In other words, is that intended or was that
Part of the,
oversight? Was it really supposed to be part of the 500 now? But keep in mind, for the Budget Adjustment Act 500, we've already incurred a debt, if you will, that we incurred charges.
you gotta, that may be backfilling that.
And we're going to be getting paid that money. That's my understanding.
Okay.
And so, having resources available to, financial resources available to go forward, my hope is that it really is in the 2027 budget too, that what's in the summary that would be going forward because it gives us more of an opportunity to bring in resources. And those resources, as you know, include transports, being able to pay for transports to get people to court. It includes it also includes, to the extent necessary, backfilling judges. If we're going to have judges taking time to one day a week or whatever it may be in a certain court, focus on 5+ dockets, we want to have continuity. So my plan is not to use retired judges for that, but to use existing judges. And then what we also don't want to have happen is we don't want to be taking a judge from courtroom 1A, moving him or her to courtroom 1B and shutting courtroom 1A down. We want to do both. And so my thought is we can bring in retired judges to backfill. If we use a judge, for instance, we'll take Rutland, for example. If we were going to, the plan probably would be to bring the civil judge down to help out. Well, I'd like to have somebody back up in civil. So maybe retired judge availability. And so funding is important.
James and then Connor.
So judge, sounds like a good idea, but when you're dealing with retired people, how long is that sustainable?
It's sustainable for, I'd say, short periods of time until they realize there was a reason they retired. So you're exactly right. We have seen that happen.
2-3 months.
But I have some judges who have committed, like Judge Maley.
I have a part two to that. So then would you envision a plan of using retired judges in the short term and trying to get new judges somewhere, like bringing more judges online in the future?
My hope would be that if you look at the numbers from the Chittenden program, they were pretty impressive for what they brought down for the dockets. My hope would be that if we focus for an intensive period of time, that we get to the point where we don't need to continue to have that type of focus in that docket. But my hope also is that the resources that we make available to individuals is how we treat everyone coming into the courts.
Right.
Whatever, you shouldn't have to be we shouldn't have to wait till you hit 5 cases to say, okay, great, now you can come in and get resources. We want to get the resources on day 1 to stop, but we recognize the practical limitations.
Yeah, and I understand like you're dealing with the backlog, COVID is some of it, et cetera, and it takes a while. There's other reasons, but and once you get through backlog, maybe it does level out. But I just didn't know if there was a thought or a plan for long term saying we just in general needed more judges, more prosecutors, et cetera, to get this to not be a problem.
The other aspect that I think is important to keep in mind is these are cases we have to hear anyway. In other words, they're cases that are going to be moving forward. And so what I've been trying to do with the judges, I've asked all the judges when I send out the list, I wanted a plan from each county as to what you would do to address the cases. And some of the plans talk about, we're going to have one of my suggestions is we need a separate day. Chittenden's going to have Fridays. Every Friday is going to be the 3B docket continue. And so if we use Rutland, Washington, whatever county it may be, if we say it's going to be whatever day, even if it's the normal judge, even if the regular judge, even if we can't get backfill, at least the benefit is everyone knows that's the day. and maybe resources can be there. Maybe Washington County Mental Health says, look, we know they're doing a 5+ docket on Friday mornings. We'll show up then. Rutland has already made arrangements with Rutland Mental Health to come to arraignments. And so if we identify a time, if we make it clear to everyone, this is when we're going to be doing these cases, I think it enhances the potential for them to show up and give us what we need. And so even if we don't get extra judges, there's benefits and lessons that we can take from what we've been doing at Chittenden.
Yeah, kind of along the same lines, you know, I was left less than enthusiastic yesterday after hearing about the pretrial supervision. It didn't sound like it was clearly defined. It didn't seem like the outcomes were even likely or defined as well. And I just keep coming back like, and it's like kind of what you're saying. Do we have the structure in place already? And we're getting too cheeky and overcomplicated with it. And the real answer is like, I'm on judicial retention. These judges coming before us are burned out, you know. State's attorneys, they need people. Public defenders need more people. So is the structure in place and we're just not resourcing it. And we're trying to get too cute, you know, with these different programs, home detention, pretrial supervision, when really we just got to be pumping money into the system that would work and go back to the old days, like you're saying, where people had more time, you know.
And that's the goal. And when you talk about, you use the phrase burned out, I like to recognize that that no one in the system, I hope is not quite burned out, but that they are appropriately tired. And we recognize everyone is working at maximum capacity. And what can we do to do? And so is this plan under this program, what works better for a state's attorney, a defense attorney, or the court to schedule? Having a process where we're going to file this paperwork for a pretrial supervision. It's then going to go to DOC and they have to look at it and they have to analyze it. And then it's going to come back to the court and the court has to bring everybody in and then we have to enter an order. And so step by step by step, and that's time. Does that contribute to somebody having, oh God, it's a long day, as opposed to saying, well, they were here at the court that day, everybody got together and we sent them out the door with this program. In other words, the pilot docket, as you point out, in many ways simplified this down to, we didn't need to take those extra steps. And I think that simplicity sometimes is something that can help. And again, it's a policy determination for the legislature. There's two components to this again. Component one, treatment needs that DOC is supposed to help with, and component two is the supervision. And is there a way possibly that you look at it and come up with the conclusion that there's a better way to do it? And maybe even financially it's cheaper.
So let me go through the finances. We put in for pretrial supervision FY25, $660,000. There was also $650,000 put in for pretrial supervision during the current fiscal year, FY26. So we're at 1.1 million, 10, whatever. And some of that has been expended because we did have the program a little bit in Essex, Orleans, and then got shifted to Chittenden. So you don't have the full 1.3 million, close though. And then the governor has proposed 200,000 for FY27 for pretrial supervision. So you're at 1.5 million. Just put that on the table for people to think about.
You can obtain a lot of resources, $1.5 million.
And it may not be a full 1.5 million because some things were expended in the pretrial supervision, particularly out of the 660,000. But I'm just wondering where we go, and I'll tell you, my gut is telling me
Is what? So
where we go with this program,
that is.
telling me to scrap it.
Yeah.
Oh, absolutely.
Yeah.
That's
I don't think you're gonna get too much.
And maybe if you want to hire folks, because the governor's proposal is for that 200,000, top of the others that's there, to hire 7 P&P folks, permanent positions. I don't know if you need the folks, or maybe you do need some of those folks. I don't know. And then you redirect the funding to the accountability court or something. I don't know.
I know that DOC, again, when their employees were there, not just the pilot docket, but when they can be in the courtrooms and available as resources, it has been very helpful. And I would say it helps in moving cases, and it helps in making sure that when you move the cases, the results are more informed, and that enhances public safety and outcomes. And so there are benefits to having employees. I don't know the numbers and structures, but there are benefits to having the DOC people at the table, as we've seen.
So were they based out of the field office?
When in Rutland, yes, they were. In Burlington, I don't know for sure. I believe they were coming over from Burlington PNP, but I can't be positive.
I was just going to ask, did it work in all the different court houses around the state? Or just was it in a couple?
When you say that, like, liaisons, does it work everywhere? Every court I've been in, when I have had DOC in the courtroom as someone to be able to give information, I have found it to be a positive benefit for moving cases along and taking care of matters.
The reason I ask is sometimes we'll hear it'll work in one county or another,
Mhm.
but maybe not another, just depending.
I can tell you that I remember in Rutland, someone was there all the time. In Barry, in Washington County, we had people there. In Caledonia, there were people there often. Orange County, not much because of the location. If we needed someone, we had arraignments, I believe, on Wednesdays, and so they would come on the arraignment day. So that, I guess I would say, yeah, they were there because that was our day. So that my experience, and I don't know how much it's changed in the past 2 or 3 years, is that they do show up and they're helpful. But I know that they're struggling. They were pulling people, back into the facilities. And so I get those stress points.
I'm presuming pilot docket and accountability court are synonymous.
I refer to it as a pilot docket because every docket, every court in our state is designed, and our system is designed to assure accountability. Only the Supreme Court can establish a quote court, and the Supreme Court did not establish a court. So accountability court is what people call it, and I try to just 3B docket, pilot docket.
Yeah. Just don't like to assume.
Yeah, that's a good question. Same thing.
Other questions, thoughts?
I like your instincts, Joe.
Yeah.
Yeah, I was beginning to feel this yesterday. It's just
Yeah.
like,
You're not gonna get opposition, I don't think, on opposition.
And again, there's the intent and what was the goal of this. Resources and supervision are important. And the question and the difficult decisions that you have to make is this the best way to do it? Or has experience now taught us that maybe there's a better way that even financially might be better and could potentially lead to better results and actually be utilized?
yeah,
Because
the money's there in the system right now.
I didn't think we'd have a situation where I'd be sitting here ever in your committee with numbers from a program that were less than home detention.
No.
I just didn't think that would happen.
Anything else of the judge before we go to lunch?
Really helpful.
Thank you, sir.
Thanks.
Thank you very much.
Very helpful.
Appreciate my-
Confirms the testimony we received yesterday.
And thank you for your accommodation. I appreciate it. It's,
Bravo. Thank you.
We got anything for you, Judge?
Don't say
you're very kind.
that. So we're done. We're back here, 1 o'clock, right?
Back at 2, are we not?
Two?
Because we were supposed to be done.
Well, I want to come back earlier because you really need.
Get back on 30.
What?
She wants to
Yeah.
talk about some of these.
Because I really want committee discussion on some things.
Okay. Yeah.
Okay, so we're back here at 1.